We are now going to turn to a new category of exception, and these are fighting words. So again, we've talked so far just about incitement in terms of areas of speech that are not protected by the First Amendment. So first we talked about incitement, which, as a reminder, incitement and fighting words are related, but they're different. So in both cases, incitement and fighting words, the state's interest in interfering with a citizen's speech is to keep order, right? So these are types of expression that are that have the potential to provoke disorder. But with incitement, the direction is different, right? So remember, with incitement, the disorder is incited, right, by the speaker, but the speaker then encourages potentially the audience to go out and commit unlawful acts or violence, usually against a third party, right? So the speaker speaks, the audience listens, the audience then goes out and attacks someone else, right? Or carries out unlawful acts against someone else. Fighting words are a little bit different. The concern with fighting words are actually that the speaker will provoke the audience to attack them, right? So the speaker is both the person engaging in expression and also the potential target of violence. One way to think about fighting words are these are like provocations. It's very rare that the court will treat speech as unprotected for the protection of the speaker, right? This is generally considered kind of paternalistic, and the court shies away from paternalism, especially in free speech cases. But the concern with fighting words isn't necessarily the well-being of the speaker, right? These aren't prohibitable for the speaker's own good, but rather these are prohibitable or punishable because the state has an interest in preventing disorder. This will become a little bit clearer as we see how fighting words evolves between Shaplinsky, which is the first major landmark case, and Cohen versus California, which is the current standard. There are a few key ideas that I'm going to refer to in this voice thread that I'm just going to preview briefly. The first one is the concept of hate speech. Now, remember, there is no category of exception for hate speech in the United States, right? This is kind of an unusual feature of US free speech law. Generally, though, hate speech refers to speech that is directed towards defaming or bringing into contempt a group of people, right? So hate speech isn't directed against one person. It is directed against a group of people, and traditionally, that group membership is decided or is defined by something that is like unchosen or that is, a historically disadvantaged group. So we see hate speech directed, for instance, towards people on the basis of their race, their gender, their religion, their sexual orientation or gender identity. We don't see hate speech directed towards groups of, say, Boy Scouts or JCs, right? These are just not historically unpopular groups. Okay. Also, if somebody criticizes your opinion, even if they're rude, that's not hate speech, right? That is simply expressing another opinion. Hate speech has to be directed toward a group, and it has to be targeted towards a particular feature of that group, right? That is then sort of like defamed. Okay, the next idea is hostile audience. So a hostile audience is exactly what it sounds like. This is a group of people who are being addressed, usually in a face-to-face fashion, by a speaker who is espousing positions that that audience does not endorse, right? And that they may oppose very strongly. You can kind of maybe try to think of your own examples of this, right? Where you've potentially seen someone address a hostile audience. This is kind of like Milo Yiannopoulos' stock in trade, right? So he wants to go places where he is not wanted, and whip up a hostile audience for his kind of own purposes. Hostile audiences are important, though, when we talk about fighting words, because again, the concern there is that the disorder or the violence is going to be directed towards the speaker by the audience. Third, face-to-face interactions. Again, exactly what they sound like. This is important because there's an immediacy piece to fighting words, just the same way as there's an immediacy piece to incitement. So you're not going to see somebody falling into the fighting words category because of a tweet. the same way that you can't incite people over Twitter, there just isn't the kind of immediacy. So again, harken back to when we were first talking about incitement, we've got some kind of theory of agency going on here, right? So who is responsible for a person's actions? Well, in incitement, we're basically splitting the responsibility for some kind of unlawful action between the person or group that commits it and the speaker who encouraged them to do it. Now, to exercise that kind of influence, the assumption is that there has to be some kind of face-to-face interaction, because without that, the people who are going to take part in the action have an opportunity to reflect and decide not to do it. So it's the same thing with fighting words, right? So, if a speaker is addressing a hostile audience, in the case that they're tweeting at this hostile audience, somebody who reads the tweet is really angry at the person who sent it. They have to go through all sorts of steps before they go punch that speaker in the face, right? So you have to read the tweet, set down your phone, get in your car, drive to wherever the speaker is, knock on the door, punch them in the face. Every one of those steps is an opportunity to not do what you're going to do. And with every one of those steps, the speaker gains more responsibility for their actions. And so this is the same in the case of fighting words. So you can only provoke someone to retaliate against you in a face-to-face fashion. Again, maybe you offend somebody on Twitter, same thing. They have to go through all those steps before they come knock on your door and punch you in the face. All right, so heckler's veto. The heckler's veto is both a metaphor and a doctrine. Okay, so the heckler's veto is trying to sort of articulate a principle. The idea being that the worst behaved person in a conversation shouldn't be the one who gets to set the terms. An example of this would be, well, just because, if I say something that really upsets somebody and then they threaten to punch me in the face, there's a moral hazard in me deciding not to speak because this person who can't control their temper threatens to engage in violence, right? We don't want to set up those incentives where threatening to engage in violence or disorder means that you kind of win. So the idea behind the heckler's veto is that, the worst behaved party to a conversation should not be the one who gets to set the terms of what gets to be said and what doesn't. I'll go into the heckler's veto doctrine in depth at the end of this voice thread, but that's just the kind of preview. Underbreadth. Okay, so we've talked about overbreadth, right? We've encountered this idea before. The problem with laws that are overbroad is that they not only punish unprotected speech, but they also punish speech that should be rightfully protected by the First Amendment. So a law can be struck down for being overbroad, right? For the same reasons that it can be struck down for being vague. We will see in this section of fighting words and then in the transition to hate speech, the concept of underbreadth introduced. And so this is a very limited concept, but it's exactly what it sounds like, right? So the problem with underbreadth is that it targets too little. Why is that a problem? Well, really, this is another way of saying viewpoint discrimination, right? So a law that doesn't just punish all fighting words, but only punishes fighting words about, say, people with blonde hair would be underbroad because it shows viewpoint discrimination. It's too specific. Okay, and then finally, public forum, which I talked about in the last voice thread. So public forums, again, are very important often in fighting words cases because these are always public speech cases. And the place that they take, where they take place ends up being important in how they're treated. Fighting words becomes a category in the first place with this case, Czaplinski versus New Hampshire. So this case was decided in 1942, and this is when the court carved out a new area of exception that they refer to as fighting words. Okay, so let's look at the facts of Czaplinski versus New Hampshire. Your book addresses this a little bit, but I'm just going to talk about it briefly here too. Okay, so Walter Czaplinski belongs to a minority religion in the United States in 1942, and it's an unpopular religion. Guess which one it is? Correct, right? So Czaplinski is a Jehovah's Witness. He according to his religion, is, he has an obligation to proselytize or spread the word. So he was out on a public street selling material when he was attacked by an angry mob. So the police arrived, and who did they handcuff? Do they handcuff the members of the angry mob? No, they do not. They handcuff Chaplinsky. So Chaplinsky demanded to know why he's being arrested. One of the officers told him, and I quote, "Shut up, you damn bastard," end quote. To which Chaplinsky replied, and I quote, "You damned fascist and a goddamned racketeer," end quote. Okay, so we have insults exchanged between Chaplinsky and the police officer. And for saying that to the police officer, Chaplinsky was charged with breaking a law that prohibited the use of any, and I quote, "offensive, derisive, or annoying word to any other person who is lawfully in the street," end quote. Just take a moment and think about all of the different interactions that you have probably had in your life where you would have been in violation of this law, right? So prohibiting any offensive, derisive, or annoying word to any other person lawfully in the street. This could incidentally reach to something like swearing in public. Okay, so the legal question that arises in Chaplinsky is, does a state law that prohibits the use of offensive words to someone on the street violate the First Amendment right to freedom of speech? What does the court hold? No, it does not violate the right to freedom of speech. And in fact, this was a unanimous decision ruling in favor of the state of New Hampshire. Okay, so the court comes out and says, first, the right of free speech is not absolute at all times and under all circumstances. Right? There are certain well-defined types of speech that can be regulated. They say, again, this is 1942, these include the lewd and obscene, the profane and the libelous, and insulting or fighting words. So this is the establishment of this category here. Okay, so they say that these utterances are no essential part to the exposition of ideas, right, and are of such little social value that any social interest in order or morality outweighs the expressive right to use them indiscriminately. Okay, so then the court offers a test for deciding what is, what would fall into this category of fighting words and therefore not be constitutionally protected. So the test is whether men of common intelligence would understand these words as words likely to cause the average addressee, right, or recipient of the words to fight, right? Would the reasonable person expect the words that are being spoken to provoke the hearer to violence? Okay, so the court goes on to say that the statute here does no more than prohibit face-to-face words that are plainly likely to cause a breach of the peace by the addressee. Okay, so I'm going to just first identify the first justification. The standard that's being used is the common person. So whether someone of common intelligence would be likely to understand that these are the kinds of words that will provoke someone to violence. Okay, the justification being that the state has an interest in suppressing breaches of the peace. However, there is another justification present here in Chaplinsky, and this language is important. Right, so they talk also about words that, and I quote, inflict significant emotional injury by their very utterance. Right, so this is accepted here. You can see this on the slide. So first of all, the court expresses the state's interest in preventing a breach of the peace, but then we have the second justification, which is the infliction of emotional injury. So we see different injured parties. One is the state, right? The state's right to keep order has been insulted. Two is the person who hears it, right? And so the harm there is that that person now, just by the utterance of these words, has had a significant emotional injury inflicted upon them. All right. This is an important point because this is where the root of the US's not having a hate speech exception begins. Now, if nothing else had ever been decided, we could look at Chaplinsky versus New Hampshire and say, not only does this provide grounding for a fighting words exception, but also for a hate speech exception. Because what is hate speech other than words or expressions that by their very utterance inflict emotional injury. Okay, so we'll sort of follow how this develops, but just as a preview, by the time the current standard is set, which is Cohen versus California, this language from Chaplinsky about words that by their mere utterance inflict significant emotional injury, that language is gone. And in fact, the nail in the coffin of that language is Hustler magazine v. Falwell, which you read in the libel section. All right. Other landmark cases on the way, Beauharnais versus Illinois, right? So this was what might be referred to as a group libel case, right? So the US no longer has a group libel category either, right? This isn't something you can be charged with. But in Beauharnais versus Illinois, that's exactly what happened, right? So Beauharnais was leafleting, people on the street with this racist anti-Black propaganda, right? And so he was charged with group libel. The law forbids any expression that, and I quote, portrays depravity, criminality, unchastity, or lack of virtue of a class of citizens, right? So this is a group of any race, color, creed, or religion, right? Or which exposes the citizens of any race, color, creed, or religion to contempt, derision, or obloquy. Okay, so to clarify, this was the charge in Beauharnais versus Illinois, but this charge no longer exists, right? The US legal system does not recognize group libel as existing. Libel can only be undertaken against individuals. Again, if Beauharnais versus Illinois were still standing law, we would also have grounding for hate speech, but both of these have been superseded. All right, so we have similar issues coming up in Terminiello versus Chicago and Feiner versus New York. These are, again, public speeches that are directing derisive, insulting, defamatory even words toward groups, right? So Terminiello versus Chicago is an interesting case because the crowd was so upset by what Terminiello was saying in this racist rhetoric that the police had to arrest Terminiello for inciting a riot for his own protection. Okay, so the court held in this case that speech could be restricted only in the event that it was, and I quote, likely to produce a clear and present danger of a serious substantive evil that rises far above public inconvenience, annoyance, or unrest. Okay, so that should all sound familiar, right? Remember, we've seen clear and present danger before. This was the court kind of trying to adopt that reasoning and put it in a different context. And again, we see this idea of the substantive evils that Congress has a right to prevent, right? So what they're trying to do with this language in Terminiello is say, like, okay, it's not enough that the speech be unpopular. It needs to be posing an imminent danger of a breach of the peace. So ultimately, when we get to Cohen is going to draw very heavily on Terminiello. It doesn't use exactly the same language, but it uses the same reasoning that, inconvenience, annoyance, that's not enough to, outweigh someone's expressive rights, but, an imminent danger of a breach of the peace is. Okay, so this brings us to Feiner versus New York. So this case is, I think, kind of quaint to modern ears because, we see Feiner recruiting, for a leftist cause, and he insults Truman in, as I say on the slide, spicy language, but it's sort of nothing compared to modern insults, right? So for his very sort of mild insult of Truman, Feiner is arrested. And he was arrested for inciting a breach of the peace. In a lot of fighting words cases, similarly to incitement cases, there isn't always a very clear thing to charge the speaker with. And so what is often used is this, right? Inciting a breach of the peace. Sometimes inciting a riot, right? That's pretty specific. But we might also see disturbing the peace, disorderly conduct, right? So these are kind of very broad catch-all charges that we see coming up in a lot of these cases. And that was the case here. So there's an important doctrine, though, that comes out of Feiner versus New York, which is the heckler's veto doctrine. Okay, it first appears actually in the dissent to Feiner, as so many important doctrines do. It appears not in the opinion, but the dissent. So I'm going to now just, again, revisit this idea of the heckler's veto. So let's just kind of take a step back from the situation in Feiner. Okay, so you've got Feiner, he's talking to a crowd. He's saying nasty things about President Truman, and somebody in the crowd threatens to punch him in the face. Now, do you think that we want to set the precedent of giving the person who threatened to punch the speaker in the face his way, right? Do we necessarily want to encourage members of crowds to threaten violence? No, right? But if every time a speaker potentially, riles up a crowd, a policeman steps in and takes the speaker away, what is this going to encourage crowds to do, right? So this is the idea behind the heckler's veto, right? We don't want the heckler in the audience to get the last word on who gets to speak and who doesn't. All right, so the heckler's veto doctrine kind of lies dormant between Feiner, which, as you'll recall, was like quite a ways back, until 1963, when it is revived, in this case, Edwards versus South Carolina. So this case is, the facts of it are really appalling. This was, again, 1963, height of the civil rights era. And so Black students were publicly protesting discriminatory laws outside of a state government building. Now, this was sort of like the epitome of a peaceful protest. They were singing protest songs, right? Like, they were not pushing and shoving. There was no yelling. But nonetheless, they were arrested and charged with a breach of the peace. And so we see in this decision the heckler's veto doctrine that was introduced in Feiner applied. Okay, so the basic idea behind the heckler's veto doctrine is that, if an agent of the state is going to step in and stop a speaker, to prevent an imminent breach of the peace, they can only do that, right? They can only make that incursion onto the rights of the speaker if there is no reasonable opportunity to prevent the disturbance of the peace by other means, right? So the heckler's veto doctrine is meant to give guidance to police officers, essentially, right? So their priority should be protecting the First Amendment rights of the speaker. Here it is in its formal form, right? So this is as it was articulated in Feiner and then applied in Edwards versus South Carolina. All right, so if the content of the speaker's views is otherwise protected speech, a mere heckler's veto is not grounds for making the speaker stop. What does this mean? Well, if the speaker is up there engaging in expression that is not otherwise a category of exception, right? So if you're up there inciting the crowd to violence, then you can't, invoke the heckler's veto doctrine and say the police shouldn't have stopped me. Similarly, if you're up there engaging in libel or obscenity or any of these other areas that are not protected. But if the content of the speaker's views is otherwise protected, then simply, trying to keep the crowd orderly, right, isn't enough reason to make the speaker stop. All right, so this leads to the second point, which is that a police officer's first obligation is to try to control the hecklers, right? So the disorderly people in the crowd first. And so the priority then is not to sort of like placate the crowd, but to protect the speaker's free speech rights. Third, all right, so if the disorder continues brewing, the officer may order the speaker to stop speaking only if the officer reasonably determines that this is the only way, right, to preserve the peace. At this point, the state's interest in preserving order outweighs the free speech rights of the speaker. And then finally, and this is interesting, please do not try to generalize this principle to anything else, because this only applies in the First Amendment context, and it's a very, very risky gambit. But the final point of the heckler's veto doctrine is that a speaker has a constitutional right to disobey an unlawful police order in this particular context, which is to say, if a speaker is addressing a hostile audience, and this, the police haven't tried to quell the audience first, but they come first to the speaker and say, hey, you've got to stop, then the speaker has a constitutional right to disobey that order because it's an unlawful order. Of course, if the court looks at this later and determines that the police order was legitimate, then the speaker does not have that First Amendment defense available. All right, so this brings us finally to the case that establishes the test. This case is Cohen versus California. It was decided in 1971. Again, we have the backdrop of the Vietnam War, right? So highly unpopular war, highly unpopular draft. So someone wrote, and I quote, "Fuck the draft and stop the war" on Cohen's jacket. The next day, he entered a Los Angeles County courthouse wearing the jacket and knowing that the message was on the back of the jacket. And so although Cohen removed the coat, right, the jacket with the offensive message, before he entered a courtroom, a police sergeant had noticed it in the hallway. So the officer asked the judge to hold Cohen in contempt. The judge refused. The officer then took it upon himself to arrest Cohen for, and I quote, "willfully and unlawfully and maliciously disturbing the peace and quiet by engaging in tumultuous and offensive conduct," end quote. All right, so the legal question that arises here is, does the First Amendment protect a person's right to wear on their person a political statement, right? So on their clothing, that includes obscene language. Okay, so what does the court hold? Yes, the First Amendment does protect a person's right to wear a political statement that includes obscene language on their clothing. All right, so this case gave the court some trouble, right? So remember in the last voice thread, we went over expressive conduct. And so the first question that the court asked was like, okay, is this expressive conduct or is this just expressive or like expression? And it's a bit confusing because on the one hand, you do have written ideas, right? This is all in fact about a written word, like that, the F word, right? So that really was the center of this question. But what Cohen was actually charged with was disturbing the peace and offensive conduct, right? Well, what's the conduct? Wearing the jacket that he happened to know, or that he knew included this offensive word. All right, so Justice Harlan writes the opinion of the court. This, by the way, was a 5-4 decision, so again, not a grand slam by any means. So Harlan says that the only conduct that the state was seeking to punish in this case was actually communication, right? So Harlan says this was expression. This wasn't punishable conduct. So he says the conviction itself rested solely upon speech and not upon any separately identifiable conduct that the state had any legitimate interest in regulating. All right, and so Harlan goes on to say that the conviction here rests squarely upon Cohen's exercise of freedom of speech, right? And that freedom should be protected from arbitrary governmental interference, and that interference could only be justified, if at all, only as a valid regulation of the time, place, and manner in which he exercised that freedom, right? But not as a prohibition on the substantive message being conveyed. All right, Harlan goes on to say, this is not an obscenity case, right? So one of the arguments for not allowing Cohen to wear this jacket in public was that the language was, and I quote, obscene, right? So Harlan applies what was at that time the current obscenity test. And he says, this is not an obscenity case. The words used here are not going to conjure up any, and I quote, psychic stimulation in anyone likely to be confronted with, Cohen's, and I again quote, crudely defaced jacket. He does, however, say the state can prohibit fighting words. However, these words do not fall into the class of fighting words. Why? Well, because the words on the jacket were not employed in a personally provocative manner, right? The words could not by any reasonable person be construed as a direct personal insult. Okay, and he also says this is not an instance in which a speaker is intentionally trying to provoke an audience to a hostile reaction. So what comes from Cohen versus California, among other things, is the test for what now qualifies as fighting words. So this is it. It's on the slide here in bold. Fighting words are those personally abusive epithets which, when addressed to the ordinary citizen, are as a matter of common knowledge inherently likely to provoke a violent reaction, right? Sometimes this is phrased an imminent breach of the peace. All right, so each of these pieces is important. So number one, the things that are said have to be personally abusive epithets. So they have to be directed to someone in particular, right? You can't just be like, oh, you know, I really can't stand people from Ohio. That's not enough. Unless there's like, you know, someone who you happen to know is from Ohio standing right in front of you and you say that and it's directed to them, then potentially that might be personally abusive enough. We see again the revival of this ordinary citizen standard, right? So when addressed to the ordinary citizen, that person would reasonably expect, right, or as a matter of common knowledge, that those words are likely to provoke a violent reaction, right, or an imminent breach of the peace. So one way to think of fighting words is, you know, if you get in someone's face and insult their mother, that is kind of like the paradigm case of fighting words. Any reasonable person would know that that abusive epithet, which epithet, by the way, means name, but this can be sort of more broadly construed to be any kind of abusive language. But yeah, so if you get in someone's face and you insult their mother, right, that's an abusive directed epithet that the average ordinary person would know, as a matter of common knowledge, is likely to provoke a violent reaction. Note, however, that by the time that Cohen comes along, that language from Chaplinsky about language that, you know, by their very utterance inflicts a significant emotional injury is gone, right? So this is language from Chaplinsky. So Cohen significantly narrows the standard for fighting words, right? So when I talk about libel, we will touch on the Hustler magazine versus Falwell case. And Falwell kind of like reaffirms the abandonment of that language from Chaplinsky. Okay, other sort of like points to note about the Cohen decision. Number one, you know, so Harlan goes on to make some other arguments about Cohen's jacket. By the way, if you look up South Carolina state laws, there are some regulations that really skate on the edge of violating the decision in Cohen, right? So laws controlling the use of profanity in public, of displaying, you know, like spicy language in public, those really are constitutionally questionable, right? So for this reason, so Harlan says, you know, the ability of government to shut off speech just for the purpose of protecting others from hearing it needs to be supported by substantial policy interests. It's not sufficient that the language is offensive, right? So you have a constitutional right to engage in offensive language. As Harlan says, anybody in the Los Angeles courthouse where Cohen walked in with his jacket had the option of averting their eyes, right? They didn't have to look at his jacket. It wasn't that intrusive. Number two, he says that the right of free expression is powerful medicine, as he says, right? So in a society as diverse as the United States. And so the air might be filled, as he says, with verbal cacophony, but this is a strength, not a weakness. So this is kind of like hearkening back to Brandeis's argument that the remedy to speech that you don't like isn't silence. It's more speech, right? So this is Harlan basically defending the right to be offensive. And there's a famous line that comes from this decision, which is, and I quote, "One man's vulgarity is another man's lyric." Okay. Now, as I said, this was a close decision. So Blackmun, Berger, and Black, say that 3 times fast, all dissented, right? So they argue that Cohen's expression was mainly conduct. They say that this wasn't really about, any substantive political speech being conveyed to an audience, but rather this was conduct and, under the Chaplinsky standard, therefore punishable. They, of course, did not get their way. So to reiterate, Cohen versus California is the current standard for fighting words. So this is it here on the slide, those bold words. That is what constitutes fighting words and nothing else. So the fighting word standard is going to be important in a number of cases that we're going to look at. These are, obviously always very upsetting cases. So your book touches on this one briefly, National Socialist Party versus Skokie. And so this dealt with a very offensive demonstration that was supposed to take place in Skokie, Illinois. Okay, so again, 1977. At this time, Skokie, Illinois had a population of 70,000 people, of whom 40,000, over 40,000, were Jewish, right? So this is, a majority Jewish town. In addition to that, Skokie, Illinois in 1977 had the highest concentration of Holocaust survivors in the country. So this is, right, in this particular instance, a neo-Nazi group wanting to hold a demonstration was particularly provocative, right? This is a really aggressive move on their part. So Collins, who was the leader of the Nazi Party in the USA, wrote a letter to the city of Skokie objecting to the bond of $350,000 they were required to pay before being issued a permit to use the park. Right, so Skokie's argument for demanding, so $350,000 is a lot now, but in 1977 it was a lot. But the city's reason for asking this was that, look, this is an extremely provocative demonstration here, especially. And so this is, it's dangerous. This is very likely to provoke a riot or uncontrollable violence. We need this large amount of insurance to cover any possible damages or, security costs that are likely to come from this. So the Nazi Party of the USA, Collins specifically, challenged this, saying, look, this is a First Amendment issue. The city of Skokie is burdening our constitutional right to hold this demonstration by, imposing this really burdensome fee on us. So, this came before the Supreme Court. This was a really, as you can imagine, divisive case. And so the court was, really sort of put in this position where they had to make a very unpopular call. And they ultimately ruled in favor of the National Socialist Party, saying that, as loathsome and disgusting as their message was, it didn't actually fall into any of the categories of exception, and the city of Skokie did not have the right to discriminate in terms of viewpoint, right? They couldn't deny a permit, right, or upcharge the National Socialist Party when they would not necessarily have had the same charges for another group, because that constituted viewpoint discrimination. So one of the questions in this case was whether or not this demonstration constituted fighting words, right? Because we have the dynamic of an aggressive speaker looking basically to provoke a conflict with the audience, and, as you might imagine, an extremely hostile audience. However, applying Cohen, the court found that these actually don't, this demonstration didn't meet the Cohen standard. Right? So what are fighting words? Well, those personally abusive epithets. There were no personally abusive epithets here, right? So there was, there was what would be considered hate speech, which is to say defamatory or language bringing into contempt a group of people. But again, the US does not recognize group libel anymore. So this did not meet the Chaplinsky standard. I'm sorry, this did not meet the Cohen standard of being personally abusive epithets. And so this case actually ultimately ended up being kind of a non-starter because they just couldn't get any support. In Skokie, the case got national attention, but ultimately this kind of fizzled out, right? And so when they did finally hold their demonstration, it was like very sparsely attended, and it was kind of a nothing, right, compared to all the furor, no pun intended, surrounding it. Okay, so this concludes our discussion for now of fighting words. As you can see, incitement is closely related to fighting words. Fighting words is also closely related to hate speech, which again is not a category of exception, right? Although it is a frequently proposed category of exception. So in the next voice thread, we're going to look at some other limits on hate or on other limits on free speech. So these include, for instance, libel and slander. We're going to look also at some really sort of like tough cases. So for instance, Snyder versus Phelps. This is another case that people look at and say, like, how is this not fighting words, right? This deals with the Westboro Baptist Church showing up and picketing a funeral. So we will turn to this as we talk about libel in the next voice thread.